So good morning, everyone. My name is Olivia. I'm the project coordinator for the Small Business Development Center. This morning, we are very excited to welcome Donica Forensich and Rolando Locci. Donica is from Vidya Law Group, and Rolando is from Rolando Locci Consultants. A couple things I do want to go over this morning. Donica and Rolando will be leading the conversation. If you do have a question, please direct all of them to the Q&A box on Zoom. We will be taking questions throughout. So once we see questions hop in, we will go ahead, I'll go ahead and stop, and then we'll go ahead and ask those questions live. A couple things to mention about the SBDC. We are a nonprofit that helps the economic development of SLO County. We provide free business counseling for small business owners in our region. If you are not a client and would like to be connected to a lead consultant to receive free business counseling, you can contact us here at the bottom. bit.ly/CIE or CIE SBDC sign up is our link to sign up to become a client. If you have questions, you can also reach out to us at slosbdc@gmail.com. All of that information is listed on the bottom of this slide. Thank you to our sponsors, SBA and the California Governor's Office of Business and Economic Development, and our additional sponsor, Maynard Cooper. I'm going to go ahead and share a quick video about them.
Hi, everyone. My name is Jamal Al-Haj, and I'm a partner with Maynard Cooper and Gale in the firm's San Francisco office. Maynard Cooper is a full-service law firm of national reach with over 300 lawyers across 11 offices coast to coast. Our San Francisco practice focuses on advising emerging growth companies and venture capital firms, including with respect to equity management, financings, employment, and intellectual property matters. We are extremely proud to be a Founders Circle sponsor amongst an extraordinary circle of other dedicated philanthropists who recognize the immense value that Cal Poly's Center for Innovation and Entrepreneurship bring to the SLO community. We hope that each of you enjoys this upcoming training and workshop and are able to incorporate the knowledge and know-how that will be presented shortly to further help grow, develop, and accelerate your businesses.
All right, so I hope everyone has grabbed their cup of coffee this morning and are ready to join Coffee and Conversation. So Donica and Rolando, I'll let you guys take it away.
Great. Thanks, Olivia. I appreciate it. All right, give me 1 second. I got to share here, folks, and then we will get after it. Okay, how's that look? See that slide okay?
Yep, looks good.
Okay, great. Okay, well, good morning, everyone. My name is Rolando Locci, and my partner today is Donica Forensich.
Hello.
So a couple things about how we want to run this. Typically, it's in person, so it's a little bit different because it's web. So this truly is a conversation. We have slides just to guide us, but really we want you guys to ask questions. That's really the intent of this. Donica and I are trying to provide some of the things that we've learned, lessons, do's and don'ts, that if you do things right in the beginning, it makes things much, much easier as you go to raise money. And when we say raise money, we don't just mean investors. We mean banks or, any other, crowdfunding, right? There's lots of ways to raise capital. So, don't think just because you're not raising money with an investor that this isn't relevant to you. It is. Okay, so I've got my coffee, and let's get into it. Okay, so as I already said, right, do's and don'ts. We're going to give you some anecdotes, stories from our clients, and then of course, if you have any questions, again, please jump in and Olivia will ask us. Okay. Okay, so a little bit about me, and then and then Donica will tell you about herself. So, my firm's named after myself, but what I do is I'm a CFO for small and medium-sized businesses. I consult at the SBDC part-time as well. So, I highly recommend, if you are not a client, that you should definitely take the effort to sign up. There is an incredible set of resources that you can take advantage of, and it's free, and everyone is exceptional in their field. So if this is a good impetus for you to jump into it, I highly recommend doing it. And what I do is I advise clients on a lot of different things, right? So getting their books in order, doing a forecast, helping them present their story to investors or banks, right? And you'll find that if you take the time to have somebody help you do this, or you take the time yourself to get it in order, you're going to be a lot more successful in any capacity, presenting to investors or banks, or even family and friends that are looking to raise money from. If you've got your numbers in order and you have a strong understanding of it, you do well. Donica, over to you.
Hi, good morning, everyone. I'm Donica Forensich, and I'm a corporate attorney. I have over 20 years of legal experience. My current practice at Vidya Law, which is a small corporate boutique that I founded, focuses exclusively on startups from very early stage through exit. So I help them from anywhere from entity selection, formation, fundraising, and then exit via M&A or an asset type sale. I don't do any public company work currently, but I can help a client along all aspects of their growth and scale. And I love working with startups because I find they get the excitement from the founders and what they're working on to be exhilarating and a lot of fun for me and my team.
Great.
So we're going to start with the questions that you normally would ask yourself before you start going down a fundraising path. You want to, think about where are you going and where are you headed, and will that do you ultimately want to exit via an acquisition or an IPO? Is this just a self-sustaining business, a lifestyle business to bring you income, or are you not sure? Similarly, you want to ask, what is the money that you're going to be raising for? Are you going to be expanding? Are you going to do multiple fundraising raises over time? What do you need to grow and scale to get you to where your exit goals are? And then who are you going to raise that money from? And this might change over time as well. Is it going to be friends and family or a bank? Is it going to be institutional investors? Or you're not sure? We're going to go through each one of these things in a little more detail and then give you some examples of what we found clients do and don't do quite right. So first we're going to talk about friends and family.
And before we do that, I think this is a very important, I see this a lot with clients. They say, oh, okay, I need to raise money. And they think, okay, that's what they need to do. But the reality is you should actually really know where you're trying to go with all of this. Because if you go to someone and you go to investment and say, yeah, I just need to raise money because I want to, go public, or I want to, get to my next round of funding, that's not going to fly. So you really should take the time to ask yourselves these questions, because where you're going and who you're going to be asking money from, or whether it be a bank or investor, is really going to dictate how you present yourself to them. Okay.
That's a good point. So a lot of people start raising money with their friends and family, mom, dad, aunts, uncles, etc. The important thing when you're working with friends and family is to treat them like any other investor. And with all investors, you want to make sure you document your investment agreements, whether that's a loan, agreement for equity. And it is very important to have the terms of the investment in writing, fully documented, and so that each party can understand, what are the terms. I often hear clients say that, well, it's my mom. She doesn't care about, when she gets paid back. Well, mom might say that today, but, a year from now, circumstances might have changed and mom might need that money. And you didn't document the agreement. Now it can strain your relationship. So it could be problematic if you don't document. It's not only to protect the investor, but it also protects you and the company. And it will look better as you grow and scale the company to other potential investors in the future that you've done things correctly from the start. You've documented everything. There can also be unintended tax consequences if you don't document loans properly. The IRS can consider them gifts, and that comes with certain tax implications if you exceed the gift tax threshold amount in any given year. And then you want to understand, are your investors accredited? And accredited is a defined term under the securities regulations. And in order to, the basic rule of securities issuances, whether it's stock, options, warrants, notes, is that, you know, you need to either register those securities or have an exemption from registration. Well, when you go public, that's when you're registering securities with the SEC. So until that time, you're going to be relying on various federal and state exemptions for your securities issuances. And a lot of the exemptions rely on whether you have accredited investors. And these laws came about after the 1929 crash and in the early 30s, where people were, you know, selling shares and selling securities without any information, disclosures. They were basically selling what's called a piece of blue sky. So it's important to understand, you know, how non-accredited investors could impact your future fundraising. It's not something to lose sleep over, but it's something you certainly want to talk about. Now, getting back to documenting things, I have a couple interesting stories here. I have one that, you know, I often work with, you know, lots of entrepreneurs that come through the hot house, especially that go up through the various Cal Poly programs into the incubator and accelerator programs. And at the start of some of these programs, you know, various students come together working on ideas, and sometimes it works out really well and the teams, you know, can move forward together, and sometimes it does not. And I often see when it doesn't work out well that, and people have not documented things up front, even a simple, let's put it all on paper, bullet point it out and sign it so that we're all on the same page with what the equity split is going to be when we actually go to form this corporation, assuming our idea works, is something that is worthwhile doing. Because I've seen, and this happened very recently, where a team came together for a summer program. They didn't agree on an equity split up front. There were a couple of people that were involved, you know, had this idea and had been working on it for a year or two before they brought in the others. It ended up breaking up really badly. There was a dispute over who owned the IP, and you know, it just, if they had sat down at the beginning of the summer program and, you know, documented what they all intended to have for the equity split, it would have ended much, much better. Another company that I worked with was founded by a father and son team. And at first they worked really well together, but ultimately they decided on different, they each had different directions on what they thought was the future of the company. And at the point that they diverged in their opinions, the father decided he wanted more stock than he originally was issued. Well, fortunately, they had documented everything. And so it was, you know, the father had what he had, the son had what he had, and had they not documented everything, the father would have likely had much more leverage to hold the son hostage in order to get more stock, to have the son, you know, work on the project as he wanted. So they ended up parting ways. They still don't speak, and but they did have everything documented. So the son was able to go ahead and proceed with the company the way he envisioned. He was able to get funding and move on as well. So if he hadn't had that all documented, it really would have hindered the fundraising efforts by that company. So in the end, I think it's you know, very important, document everything and treat everybody, whether they're a friend, a family, like they are any other institutional investor.
And I'll give you guys one story of a client of mine. So this is a really good example of kind of knowing where you want to go. So this client wanted to sell, okay, and they had a suitor, and we were in discussions with them. And, you know, and through their due diligence process, they looked at the loans that we had. And, you know, most of the loans, as you would expect, since it's a small company, were friends, right? Close friends, you know, provided money. But the reality is that 4 of the 5 people that they had taken loans from, there was no documentation whatsoever. Okay, so it was really unclear whether the money was owed, or how much was owed, was there interest owed? So, you know, the acquirer, potential acquirer, started to get nervous. Their largest creditor, they had done 20 different loan documents, right? And all of them were slightly different, right? And again, it was unclear, was there accrued interest owed to this person? How much was owed? Could they demand payment? And this was an asset sale. So none of these liabilities were going to be taken, right? So the company was just buying the intellectual property. It was actually a company that actually had tangible goods. There was tangible goods, their brand, right? So you could say to yourself, oh, well, you know, they're not taking the debt. So it doesn't matter if the debt's messy. But the problem is that even if the loan doesn't state it, it can be implied that the creditor has a hold on those assets, right? So the person trying to sell the company can't really make a strong argument that they can sell the assets because somebody could make a claim after. So they walked away. They walked away from the deal, the acquiring company or the potential acquirer, right? So it's just a really good, you know, and then we had to go back and clean it up, right? And the problem is that, you know, that deal, you know, in some ways fell apart because of that, right? So you have to really think about, yeah, you're just like, oh, I'm a small company and, you know, it's just me and, you know, it's okay, I can work these relationships out. But as soon as you start talking to third parties like banks or acquirers, anything that they see that is a potential red flag, whether it really is or isn't, it causes them pause. So it's something that as you build your company, always think about how you're going to look externally and ask a third party, say, is this clean? Does this make sense to you, right? Would this pass, you know, a sniff test, right? And if it doesn't, you should clean it up. Get somebody to help you. Why don't we stop? Any questions, Olivia? Anybody want to jump in? If not, we will keep rolling, but we would definitely want this to be a conversation. So
Don't see any questions in the chat yet, but
okay.
if something comes up, I'll be sure to stop you.
Sure. All right. Okay. Okay, everybody, let's roll on. So let's talk about banks. Okay. Banks it can be a great way to raise money. There's a lot of SBA programs out there for small companies that don't have a lot of history and don't have a lot of assets. But there's a few things that you really want to do before you even talk to a bank. Okay. First, understanding banks. Okay. Banks are simple. They hate risk. Okay, it's as simple as that, right? They do fairly low interest loans, but in return, they want a combination of things. They're either going to look for collateral and or personal guarantees. Okay, and if you're not familiar with what a personal guarantee is, I mean, it's as the name suggests, right? If the assets of the corporation cannot satisfy the debt, they will go after your assets, right? So just be prepared that especially if you go into a bank and you don't have a lot of history, your business doesn't have a lot of assets. And when I say assets, I mean cash in the bank, you know, tangible goods, right? Royalty agreements, right? Banks are not interested in intellectual property, right? Unless they can sell it, right? Unless they can liquidate it. So although IP can be considered an asset, it's not going to be something that a bank's going to be interested in. So know that going in, knowing that you can get someone to co-sign a loan with you, right? Someone who has more collateral, someone who's willing to do that. You always want to take that relationship seriously and be clear about and make sure they're clear about what they're taking on, but don't be surprised if that's what a bank's going to ask you for. A lot of times bank will file what's called a financing UCC. If you've ever heard of this, it's essentially a lien on your assets. So if you've taken any loans previously with your company or in any capacity, I highly recommend you can actually do it online. It costs $5. You can run a financing UCC and it lists out all the people who have laid claim to the assets of your company. And you would, just like if you've ever run your credit report, there's always stuff on there that you didn't even know existed. There can be a lot of plaque built up on your company's side in a financing UCC. And so I always recommend that before you go talk to a bank, you should probably run your own credit report. I would recommend that because they're going to run a credit check on you. And then also to run a financing UCC on your company. So you can take a look and see. And then if there's something in there that gives you an opportunity to clean it up, it's always better to clean it up before you go talk to the bank because, again, it slows it down. And then at the same time, it's all just red flags. Anything that's a red flag, slows the process down. Right? So Donica, I think you probably got a
Yeah, and to
couple of
that
good,
point,
yeah.
yeah, it's really important, I think, before you go into any deal, not whether you're doing, going to the bank to inquire about loans and lines of credit, or also you're doing a fundraising or you're doing some type of sale to run a UCC lien search. I've had examples where clients, especially in M&A deals, they forget that they had a loan in the past where the bank had a security interest, because the banks always will want some kind of collateral. So they'll have the security interest against all of your, usually it's very broad, all of your assets, IP, everything. And then they'll file the UCC with the Secretary of State where you're incorporated. But banks often aren't good at following up when you pay off that loan. When you pay off that loan, they're supposed to remove that lien and file a termination of the UCC. And I've had M&A deal where, we ran a lien search to be cautious, because that's what we do during the deal. We have certain disclosures. And we found out that the bank, even though the loan was paid off, the bank had not released the lien. And so it delayed the deal, because we had to go back to the bank. We had to find the right contacts. We had to get the UCC termination statement filed with the Secretary of State. So, it can add a few weeks to the process depending on who you're dealing with. So it's always important, and it's easy, like Rolando said, to do that lien search and just see what's out there. And then, also when you're looking at lines of credit, banks really, are going to look at your history and your financials here. I have a current client that was looking for some lines of credit for their inventory purchases, because they have to purchase inventory before they can sell it on their platform. And, as they're growing their revenue, which has been in a great trajectory over the last year, they still have to, spend money before they sell the products. So it's always this cycle that they're dealing with. But because they're a newer company, they've had so many banks either turn them down or offer just egregious terms that don't make any sense. So it's important when you're going to get money for certain things to understand, what you need that money for and who are the best resources as well.
Yeah, and I'll give you guys all another example. So if that same client that I was working with that was looking to get acquired, there was quite a few UCCs that had been put on the company that we didn't even know about. Right? A lot of times when you talk to somebody about, there's this thing called factoring AR. If you have accounts receivable, you can actually get somebody to give you cash up front before you get paid by your clients. But you can also, kind of pre-file a UCC. With that, you actually say, hey, we're going to do business with somebody. They didn't remove any of that, right? So there was all kinds of filings on there that we didn't know about, expected that they would be removed, and they were not. So unfortunately, the onus is on you to make sure that the other party takes care of it. So do not assume that they will. Assume that they won't, and then take care of it. I'll also give you one more example just to kind of reinforce how you kind of have to expect this concept of personal guarantee to come in. I have a client who's been in business 30 years. Okay, they are an internet service provider, right? So they have stable revenues, right? But even then, they didn't quite meet the threshold for not having a personal guarantee, right? And unfortunately, that's how it works, right? Even with a long business history, banks will want to cover themselves as many ways as they can. So go in with that mindset, be prepared for that, and understand that is also a negotiation point, right? Don't assume that, ask them, right? Ask these kind of questions, because they're not going to necessarily tell you, or a good banks will, but they don't always tell you what they're looking for. So make sure you ask the questions. Are you going to take a guarantee? What kind of terms am I going to get? Those kind of stuff, those kind of things. No questions?
No questions yet.
All right. We're doing such a good job. It's so clear. Everyone's like, okay, I totally get it. All right. Okay. Investors. This is where it gets messy.
Well, it can, but you know, investors are at various stages. We usually, when we're talking about investors, break them up into categories: angels, your friends and family, people that, you know, write smaller checks that invest in various companies along the way. You know, venture capital is often broken into early stage funds and late stage funds. And then private equity, which usually comes in to acquire a company rather than do a traditional investment. I think that it's when you're looking at investors and, you know, as your target for your fundraising needs, it's important to understand, you know, what stage you're at and where your focus should be. So depending how early you are, you know, you would go to angels or early stage VCs. And then as you grow, you might hit up, you know, there might be other funds that you're looking to connect with for your fundraising needs. There's resources out there to search investors. You know, TechCrunch is a good site, in Crunchbase, where you can look at, you know, who's invested in different entities. So maybe you have a competitor and you want to see who's invested in that competitor. You can certainly do an easy search on Crunchbase without any cost. They do have a paid version to get more information, but you know, I would say target the people that you think would be good fits for your company. Read their investment thesis, understand what stage they invest in, who they invest in, and why. And then, you know, institutional investors, when we're talking about, you know, venture capitalists, private equity, you know, corporate funds as well, they're going to do their due diligence just like banks. Angels, it will depend on who the angel is. If it's your mom, she's probably going to write you a check without asking to see any of your corporate legal docs or your financial statements. If it's a serial entrepreneur type angel, they're probably going to do some minimal diligence. But when you get into, you know, your Series Seed beyond rounds, you know, it's very important that you prepare for due diligence. And I think the more prepared you are, the better your chances in being successful at raising money. Because if you cannot produce the documents that are requested in a timely manner, investors will often get leery on why you can't produce these documents. One of the things that I find is if we're scrambling to produce our diligence room, you know, at the time we're doing the fundraising, and we're fixing things, it's just going to cause delays. It's going to cause the investors to, you know, be unsure about you and the company and what they're investing in. And, you know, it's probably going to cost you more money. I always tell people it's easier and cheaper to do things right the first time than fix them later. Most things can be fixed. I think if any of you, I did a due diligence presentation last month. So if any of you saw that, we talked about that. But, you know, it's always, you know, you might say, I don't have money. I don't know who to go to, whether it's a CFO or you know, a lawyer. The SBDC has many recommendations, not only us, but others as well. And it's important, I think, and worth the cost to explore getting that advice. You know, a lot of times I see defects in preparation for diligence in the fact that people don't always have their employees and consultants sign the proper IP assignment and confidentiality agreements when they start at an organization. And it's really important to get everyone to sign these documents because those protect the company's IP ownership. And it is very problematic when you're doing a deal and a former co-founder has left 3 years ago and you're not talking to that person and they didn't sign anything to assign the IP to the company. And now you're giving representations in the purchase agreements, for example, that the company owns all of the IP and you can't give that representation. And you have to go find that person and get them to sign something. And then they have the leverage to hold out. Maybe you have to pay them more than you should. Maybe you can't find them. Maybe it's IP that you're not using now, which would be fine. But if it's core IP, it can be really problematic. So it's important to make sure from the start you have those documents. I've also seen deals fall apart, specifically an M&A deal fall apart where it was an acquisition and the acquirer was buying this company specifically for the data that they had received from its users. However, the terms of use that the target had on their website did not allow them to assign the data to any successor. So because they did not have their terms of use, reviewed by a lawyer, that cratered the deal. So it just completely, the deal went away and they were, stuck, and they were in a place where they needed to sell the company, and unfortunately. So I know there are a lot of different programs out there that in lieu of lawyers, but sometimes it's worth the money to talk to somebody that knows and has experience in these matters. So, again, depending on who your investor is, the later the stage or the more sophisticated investor, the more diligence you can expect. So when you're thinking about going out to these types of investors, it's very important to have all your ducks in a row, so to speak.
So let me tell you what I recommend you bring from a financial perspective. So number one, you should have some clean books, clean accounting. So even if you have 2-3 months, a year of financials, they're going to want to see them. And I do not recommend doing it yourself unless you have a really good accounting background. So pay a bookkeeper $30 a month, $40 a month. There's actually software out there right now that you actually get the accounting software plus an actual human in the background as a bookkeeper, right? So you don't just have to get QuickBooks and get a bookkeeper. Some of them you can get it combined, right? I recommend doing that, having somebody do it correctly, right? Because this, I can tell you from being on both sides, helping clients raise money and also being an investor, messy historical financials is a huge red flag and something you can easily clean up. And it says two things. One, are you tidy with how you run your business? And two, do you actually know what's going on? I mean, if you don't use your financials on a monthly basis to see how the business is operating, then you don't have a handle on it, right? And it really sends that message. So if you aren't doing that now, do it. Okay, so I would say that. You're gonna need some sort of projections. You're going to hear 3 years, you're going to hear 5 years. I typically just do 3. Okay. You need at least 3 though. Okay. And so what I recommend is, and I tell this to all my clients, whether they be at the SBDC or that I work privately with, the numbers aren't really the most important thing. It's the assumptions you have behind it. If you can't say this is going to be, we're going to hit this number because of X, Y, and Z, you're wasting your time. Because investors know that you can't predict the future and nobody can, but they want to know you have an understanding of where you're going, right? And I can't tell you how many times I've seen projections that are completely unrealistic. They're showing a magnificent growth, but somehow, expenses don't grow. Well, that would be great. It would be great if you had a business, you could triple your revenue and, expenses stay the same, but that's not how it works, right? So really having that connectivity. And again, I'll pitch the SBDC. I mean, you've got lots of people here that can help you, it doesn't have to be magnificent and perfect and the greatest Excel model ever. It just has to have thought behind it. And you'd be surprised something as simple as putting some numbers in with a set of assumptions at the bottom will actually fly. Okay. But I do not recommend going to anybody. And I would even say, your mom, unless you have a clear idea where you're going and a clean set of financials. And I think, I think that's it. I mean, I think having a deck together is also very important. And I don't think it matters who you're talking to. And the deck should be a representation of who you are as a business and where you want to go and clarity of thought. Again, that's the most important thing, that you actually know who you are and where you want to go. And I will reiterate what Donica said, especially when going to look for investors. I will tell you a mistake that I made in the beginning is that we would go talk to almost any investor. Okay. And the reality is that that is a waste of time. It's a waste of time for you, and it's a waste of time for them, because they want you to already know that you're a good fit for them. And one thing that I think is particularly important is that you should be looking for a person at a firm and not a firm, right? You should, when you send an email to an investor, you should send it to them, right? And why they specifically are you interested? Because this is how these investment firms work, right? You need an advocate. Someone at that firm has to be excited about you. So you have to think about this as like gates. Get somebody at the firm excited about you, and they will go pitch it to their partners. That's how it works, right? You can't sell the whole thing to everybody at once. So just sell it to one person. And think about it in terms of stages, right? Get them to accept your deck, right? Once they get your deck, get them to accept a meeting, right? Once you get a meeting, get you to present to the rest of the partners. Once you present to the rest of the partners, get them to take you into due diligence. So like, you have to think about it as stages, not as I'm going to go and I'm going to get a check in a week. It's not how it works. They all have their processes. So if you think about just taking that small bite and getting to that next gate, I think you'll be a lot more successful. Yeah, and definitely do not contact the firm if they do not match you at all. They don't invest in your stage, if they don't invest in your market, and you should send in your email exactly why you want to talk to them. And I guarantee you'll have a lot more success.
Yeah, and to that point, I think it's important not just to have your deck, but also you should have a one pager, and then you should have a blurb, like a small 2 or 3, 4 sentences that are going to be the thing that catches that person's eye and that they want to know more, because these people get so many emails and requests. And it's really important that you are able to synthesize what your niche is and why they should invest in you in a few sentences to grab their attention. And to the extent that you can find people in your network that know people that you're targeting, warm intros are always helpful as well. So think about that when you're targeting your wish list of potential funds, especially. I think it's important to think about those things, and have a focused strategy on how you're going to attack this list to get those checked. And like Rolando said, this is going to take time. Estimate what you think it's going to take and then multiply it by 3. So at a minimum, it always takes longer than you anticipate. So then the more you can get prepared early, the better off you'll be in the long run.
Yeah, I remember people used to say it takes 6 months to raise money. No, I think you never stop raising money, to be honest with you. Mm-hmm. So if you're a founder and you don't like raising money, then you should seriously consider doing something else, or find somebody else at the company who can do it, because it's a full-time job. Even when you raise money, you got to be thinking about the next round, and it's pretty much constant. So
exactly.
And it does take a long time. It just takes a long time. Yeah. I mean, even investors themselves take 4 months to make a decision, and then another 3 months to close the deal.
Yeah, and it's like Rolando said, it's gonna be a constant thing, raising money, and how you're raising your seed, and how much are you asking for, and where is this going to get you? They're going to want to know that in your financial projections, right? When you're going to need to raise again, and why, as you scale and grow. So you're going to always need to be telling that story and thinking, a round or 2 ahead as well.
Yeah, it's very important. Okay, Olivia, there was a question, but I guess no. Move on.
No questions.
All right.
Doing a great job.
Okay. I just saw, I don't know. I don't know Zoom. Something popped up. So I just assumed this question. All right. So let's talk. So we talked investors, we talked banks. Let's talk about different types of equity, just so you guys get grounded on that. And Donica's going to talk a little bit about crowdfunding, because I think it's become popular. And crowdfunding can be a good tool, but I think you have to really be clear about, does it suit you? So you've heard a lot of terms about stock, and there's lots of different ways to structure your deal. Okay, so there's how much money you need to raise, right? Number one, we went through that. Who are you going to get it from? Okay, so we went through that. Now there's lots of different ways that you can actually structure a deal. So simplest way, sell equity. In our slide, we say straight equity, right? And there's two types of equity. It's common stock and preferred stock. And in general, Okay, there's no hard and fast rules in this, but in general, founders, employees get common stock. Investors usually end up getting preferred stock. And preferred stock, there is lots of different nuances to preferred stock, lots of different rights, but typically preferred stock has special rights. And it's usually the right to invest again later on in other rounds. They usually get to the front of the line. It's called liquidation preference when there is a liquidation event, meaning they get paid first before everybody else gets paid. There's certain voting rights that they are assigned. A lot of times preferred shareholders can vote as a block, meaning they all kind of have one vote together. So this is all the more reason why you should engage a knowledgeable lawyer when you get into these discussions, because there are a lot of terms and there's a lot of things that you can give away that you don't necessarily need to, and you need to understand what you might be giving away. It may be okay. It's not really always about price. Okay, it's people I think tend to get hung up on valuation. Valuation, I would say, is actually a much smaller part of a deal structure than you might think. It's a lot of these other terms like liquidation preference and voting right and board seats. These are the things that determine what's going to happen 3 years, 4 years, 5 years from now, and whether you're going to still have control or enough control of your company, or whether you're going to come out on top, right? And not on top, come out in a situation where you feel happy, right? Where both sides are happy. So that's incredibly important. There's also convertible securities. Okay, and so convertible securities basically is a way of selling a piece of your company, but not quite selling it yet. Okay, so they can either be notes or these things called SAFE, which are simple agreement for future equity. And I'll go through both of them. And as their name suggests, they convert. They start as one type of instrument, and then an event happens, and then it converts to stock. Okay, so convertible notes, it's as its name suggests, it's a note, it's a loan. Okay, so like most loans, it has a term. Okay, it has an interest rate, right? And it has a conversion, meaning that when a liquidation event happens, either you sell the company, maybe not liquidation event, let's call it a financing event. Okay, meaning either you raise money or you sell the company, or it merges. Some sort of event would convert that to stock. Okay, convertible notes are simple documents. They're easy to do. I do not recommend getting one off the internet. I recommend getting a convertible note from a lawyer. It's worth $300, $400, $500 to have them give you a template and review it. Because I'm sure you can find one on the internet, but I don't recommend doing that. But convertible notes are easy. If you do an equity offering, it can be 50, 60, 70, 80, $100,000, right? A convertible note you can do in a couple days for a couple $1,000, right? And that's a lot of the reason why people who do angel rounds or seed welds do notes, because it's a lot easier to do. It's a lot less legal fees, and when you're raising $100,000, you're not going to spend $100,000 on a lawyer, right? So that's why convertible notes can work very well. Safes are also very popular now, and a safe is almost exactly like a convertible note, but it's not a note. It's not debt. So if you have a convertible note and your company either goes out of business or the note comes due, someone who owns a convertible note can actually come and ask for the money back. They can't do that with a safe. It doesn't work like a note, but it works almost the same way. It converts to stock at a financing event or at some sort of event, right? Just like with a convertible note. But safes, although similar to convertible notes, have certain wording and nuances that make it confusing. Even to me, I was confused recently by a safe that I saw. So again, I really recommend having a lawyer take a look at it, because although they are simple documents, 1, 2, 3 pages, it can make a big difference. But again, it's simple. It's an easy way to get to a financing event, and you actually don't have to have the valuation discussion, right? There are valuation caps that can be put into these agreements, but You don't have to decide on how much your company is worth right now. That can be delayed to a later time. And that's one of the other reasons why people use convertible notes or safes instead of equity, because you're a small company, you don't quite know what you're worth, neither does the investor, so you delay that conversation till a later time. Donica, how did I do? Did I do okay on that? Anything I missed?
Great. You did great. I think there's a question.
Oh, all right.
Yeah, so we've got one question here, Rolando.
Sure.
So at what point do you start to think about having a second kind of equity?
Second kind of equity. I'm probably going to have to ask a question and then what do you mean by second kind of equity? Meaning you've got common and.
When do you create the preferred equity?
I think that's the question. Yeah.
Yeah. And I think that's a great question. And so when you form your corporation, you're going to authorize common stock first only. And that will be used, as Rolando discussed, for the founders, for your stock plan that goes to employees, consultants, etc. You usually wait to create your preferred stock until you do your first priced equity round. So when you're doing that Series Seed or Series A, whatever you're going to call it, that priced equity round is when you create the preferred, because there's no reason for you to create it until that time. And I think that, as to Rolando's point, you really want to think about the fees, because you need the money to run your business and to grow your business. And it is, until I recommend for clients that they don't do a preferred equity round until they're going to raise about 2 million plus, maybe even 3, because like he said, the legal fees, accounting fees, etc., are going to outweigh the benefits. You don't want to spend a lot of money on fees to prepare all of the financing documents and the other items that go along with them when you're raising a small amount of money. So I think that you use the convertible notes, you use the safes for raising up to those amounts, which again, the legal fees and the finance fees are going to be much lower as well. So I think that is the way to think about it. And you can always ask your CFO or your lawyer about what is the right time. Is there another question there? So I'll pop up.
Yeah, one kind of going off of that. He was asking, how do you think of the preferred and keeping control of the company?
It's a good question. So too. There's going to be a couple of ways. So when you're thinking about preferred, if you're doing a VC funded round, the preferred stock, as Rolando had mentioned, is going to have protective provisions. So there's going to be certain things where, the basic rule under Delaware law is that everybody votes together, common plus preferred, on any action. California is common and preferred can vote together, but certain things are required under statute to vote separately with each class. Under Delaware, the preferred gets their voting rights in your certificate of incorporation, and the protective provisions are set forth in that document. And there's a pretty standard list that everyone starts with. So if you're going to amend the certificate of incorporation, if you're going to amend the bylaws, if you're going to create a new class of stock, with superior rights, if you can get that in, various things. If you're going to issue debt in a certain amount, the preferred gets those rights. So that will be negotiated in the term sheet. So that's one thing to think about. And that the strings come along with raising that money. Unfortunately, strings attached. But the one thing you want to think about as a founder with your common stock, and as you start raising preferred stock, that is going to dilute you over time, right? So you're going to think of the longer that you can maintain overall control and control of the common stock, the better off you'll be, right? So maybe the first round you give out 20% or 25%. And then each round you're going to have a little more, and it's going to chip away at the overall percentages. But one of the important things for founders is to continue to maintain, as long as possible, control of the common stock. So you want to think about, when you're forming the company, between the founders and what you're going to reserve for the stock plan for employees, what is going to be the percentages of the common. And one of the ways you continue to maintain that is, you keep your stock plan a small percentage. We usually start out with a 10% of the fully diluted cap as a stock plan and maintaining that percentage. So besides having those rights for the preferred and the overall percentages, you also need to think about board composition. And that's really important when you're negotiating your round. So at first, the founders are typically the board members. When you start your first preferred round, it's often the case where your lead investor will want a board seat. So at a Series Seed, for example, we often see the board comprised of 3 members. In the voting agreement, we negotiate that 2 of those members will be appointed by the common, often one of which will be the then current CEO. And then 1 will be appointed by the preferred, which will be designated by the lead investor. And as long as those founders continue to hold that majority percentage of the common, they will be able to continue to sit on the board. And that's a very important part of maintaining control. And then you go to your next round, we might see a 5-person board. And at that point, it's often 2 common, 2 preferred, because your first one from your first round, and then the lead from the second round, and then an independent that is designated by the rest of the directors. And that's a typical board when you start seeing Series A, B, etc. And so the more you can control that common piece, and I often get founders really, getting upset when they see their overall percentage going down because of dilution over time. But I often say, well, you still own 90% of the common. And that is a key aspect of maintaining some of your control and having that common board seat. So that's generally what you want to think about as you're raising money over time.
Yeah, really good. Hey, Donica, now I'm going to ask you a question. So this is so a client of mine's going through this right now. So we have 3 people on the board. We're going to go through a Series A, right? And typically they usually want an odd number on the board, right? So if we added, a lead seed investor, a lead Series A investor, that would be a 4th. They would obviously take a board seat. How do you think about that 5th person? And so let's say everybody agrees it should be an independent, right? Not from the firm, but from, so how do you see firms typically hash that out? Do they say, okay, we all have to approve this person. We each give our candidate and then we vote? Because to a certain extent, not that an investor would be devious, but you can subtly take control of a board by having an independent who's kind of on your side.
Sure. And that's a great question. And usually we put that in the voting agreement as well, is that that independent is approved by a majority of the then current board. So hopefully it won't end in a tie. But I find investors, they want the companies to succeed. They're not usually trying to be devious or take over the company. They're in the business of investing, not wanting to operate the companies. So and I often find it's up to really the founders to sort of seek out and start making a list of potential independents because they're, and then the funds will often give input, like, let's go talk to these people or this person, or we're not really sure about this person. So that's the way I usually find the dynamic. But, you never know if somebody has ulterior motives, but hopefully not. And
yeah. Well, yeah, you actually make a good point. I think coming to the table with the idea, that's one thing the founders and I talked about, is that we should have our list already. And I think that's a really good idea. You don't go in with your idea of who you'd want to add.
Yeah,
I think that's
exactly.
a good idea.
And you want somebody strong in the industry or strong in a certain strategic manner that's going to bring value to the company and give ideas, because it's everyone's goal to make money at the end of the day. And investors want somebody strong so they can get a good return on their investment.
Absolutely.
So I'll just do briefly, we're getting at the end of our hour here on crowdfunding. So there's various flavors of crowdfunding. I'm sure all of you are familiar with Kickstarter, Indiegogo. those are crowdfunding where it's pre-sales, right? You have a product that you're going to launch and people are paying for, to get the first of that product. And then you have, crowdfunding platforms such as Seed Invest, WeFunder, or CrowdRise, which are selling your securities. You can be straight equity or convertible security that you're selling from various people that are interested in your company, but they're not institutional investors. Maybe you want to have them contribute $100 minimum at a time. So you can get a lot of your, customers that involved. And these platforms help you comply with the SEC rules regarding the securities rules. And there are special rules about crowdfunding platforms. The thing to think about when you're exploring these options is, what are the fees? Because there are fees, there's commissions and fees based on how much you raised or how much you sell as well. And then, some of the platforms have specific requirements. For example, I had a client recently exploring Seed Invest, and they wanted 2 years of historical financials. And the company, although they've been around for 2 years, their product was only launched just a year ago. So they didn't have that, and it wasn't going to be the right fit, even though they thought they would be a good candidate for the platform. You also need to think about is what you're offering, whether it's a tangible product or some kind of service. Is it something that people on these platforms will get excited about? There are more and more investor, like angels and funds, using and seeking investments via the crowdfunding type platforms. But you need to think about what your target. I did have clients that started on Kickstarter, but after they launched, they really found out that the marketing wasn't happening as they had anticipated. So they cut their losses, pulled the product, so they didn't spend any money wastefully going forward and just having the product linger on there. So just think about what your target is when you're looking at the crowdfunding platforms, and really research, is what I'm doing going to be a good fit for one of these platforms? With regard to just selling stock, I want to make one point here is, it's when you authorize your common stock, you often say, well, I don't want to take on debt or a convertible. I don't understand that or how it works, or I don't want to hire a lawyer. I'm just going to sell some stock to my mom. You want to think about, with investors, the price they're paying for the stock. Because if you're going to sell common stock to an investor at a price that is really a premium, where they should be getting preferred, it can affect the value of your common stock for others. For example, you often want to keep the price of your common stock low, because when you're doing granting options for your employees, for example, the lower the price that they get in for, the better upside for them potentially at the end of the day on an exit. And that is more incentive to them. So selling common stock to an investor can really be a bad thing for pricing, and is something to make sure you talk to your counsel and your CFO about. Also, to Rolando's point about getting documents off the web, please do not do that. I know it's easy to do that. There are so many different forms out there. And there are some sites that have good forms, but if you're pulling them down off a site, check them with somebody that knows what they're doing, because this is not what you do every day. This is what we do. I often tell clients, I don't write code, so I'm not going to try to write code and think I know how to write code, but same thing, in reverse. I do this every day. Y Combinator, who came up with the SAFE, has the forms on their website, which anyone can download. They also have some great white papers, download them, read them so you understand them. But when you're getting ready to send out a form, have your lawyer check it first. The most common mistake I see on the SAFE is that people confuse the discount they're giving and the discount rate as a defined term in the SAFE. And that is, the discount you might give is, say you want to give them 20% off of the future preferred stock. Great. Well, the way the SAFE is written, the discount rate is 100 minus the discount. So the discount rate would be 80%. So basically, if you're selling your preferred stock at $1 a share, you multiply that by 80%, they're paying 80 cents. So the discount rate is 80%, the discount is 20%. I've had people reverse this. So when they put the discount rate as 20%, basically they're giving an 80% discount. So luckily, the one client who did this, you know, we caught it early and we were able to amend easily all of the safes, except one investor was a pain in the you know what, and made us jump through hoops before they would agree that this was really just a mistake and we weren't giving you an 80% discount. So it was a struggle. And then similar with convertible notes, you know, you need to understand the terms as well, and what the discount with the valuation cap, similar to SAFE, and how they work on conversion, how they work on a change of control. All of those are important, and that's where your lawyer can come in and have good value. And also, if your friend who's another founder just did a round and, oh, they're going to give me their documents that their lawyer drafted, well, it's good for you to read those for informative purposes, but they might have, you know, made some changes to what standard because of their investors requested this or that, and that might not be right for you. So it's really important when you're going down to start documenting things to really talk to your right advisors to get the right documents. Again, it's more cost effective to do it right in the first place than to fix it all later. So that's my key point.
There you go. That's our last bullet.
Thank you so
Costs
much.
more to fix than do it the first time. But yes, sorry to interrupt you, Olivia.
No worries. So we're approaching the end of the hour, but before you guys hit your summary, we do have one more question in the chat. I just want to get to it before we close. Donica, what are your thoughts on raising money through crowdfunding without issuing stock?
Yeah, so you can do it through a convertible security on the crowdfunding platform. So I have clients that are issuing convertible notes, for example, on WeFunder right now. And so everybody's getting notes, and then it will convert when they do their preferred round. And that's a good way, a combination for the client to raise money without spending a lot on legal fees to do a full round as well. So that's one way to do it. And then if you don't want to issue stock at all, even in the future, you would need to use a Kickstarter type because you're pre-selling the product and there's no securities that are issued. It's really an advance payment against the delivery of the future product. So those are the two options there.
Perfect. Thank you. All right, Rolando, you want to go through the last slide, or are you guys wrapping up here?
Yeah, I mean, I think we made our points, but I think the message I think that we're trying to send is, I think if you kind of know where you're going and get some help along the way, that you'll find that things are just going to be a lot easier for you. And again, I'll say it, go to the SPDC, because there's people there that can help you do it. And even if they can't do it for you, they can certainly send you the right direction so you're efficient with your time, which I think is going to be most important. So thanks for having us.
Thank you so much. So I'm going to go over a quick couple housekeeping items here. So I'm going to share my screen real fast. First of all, thank you both so much for joining us. If you registered this morning, we will be sending a copy of the recording to all of the email addresses that registered. And then a couple other things, we do have some upcoming events. So next month's Coffee and Conversation, we will be welcoming Tim Dosa from Glen Burdett. Registration link is there. It's also available on our website's event calendar. And then on March 3rd, we are partnering with Women's Business Center and SCORE to put on another workshop, Search Engine Optimization with Steve Burnside. He's the Director of Development and Marketing at Clever Ducks. Registration link is there as well. So again, thank you all so much for joining us. Donica and Rolando, that was awesome. I learned a lot of new things, and I know our attendees really appreciated it. So thank you so much. Everyone take care and have a great rest of your day.
Thank you.
Bye.